We're very lucky to have Dr. Joshua Yuvaraj join us this evening. Joshua is lecturing at Melbourne Law School. You're lecturing
Copyright and design.
copyright and design. So just while he's in Melbourne, it's a good chance to have him come in and present his work on kind of critiquing generative AI. Joshua otherwise is at the University of Auckland in the Faculty of Law, where he's a senior lecturer and co-director of the New Zealand Centre for Intellectual Property. His research focus is copyright law, contract law, and emerging technologies, particularly artificial intelligence. He's published in a number of journals, including the Melbourne University Law Review. And he's been a visiting fellow at the University of Cambridge, and he's also a member of the Australian government's Copyright and AI reference group. He got his PhD from Monash University, where him and I had a brief crossover.
Yeah, I think so.
I think about a year, where he won the Molly Holman Medal for the best law thesis at Monash in 2021. And just 3 years later, I got
It's represent. Yeah.
So he's presenting his paper, The Verification Value Paradox, a normative critique of generative AI use in legal practice. So yeah, take it away, Joshua.
Yeah. Thanks, everyone. I presume you can hear me on Zoom unless otherwise advised. Thanks, firstly, Duncan, for putting this together on reasonably short notice, and obviously at the end of the year. And I appreciate everyone taking time out on Zoom to attend. It's good to see you on Zoom tomorrow. Hopefully next time I will come and catch up and see you in person. Tomorrow, Duncan and I were kind of in the same PhD cohort. Memories which I hold very fondly. I really do. So I wanted to present work that has both been accepted by the Monash Uni Law Review and then work that's under peer review at the moment. Obviously, yeah, timing me being in the country. But yeah, I thought it is timely. There's actually a lot of research in the Australian law journals that's currently being released. The UNSW Law Journal just released an edition on AI and the law, so to ANU Journal of Law and Technology. So it's timely. It's obviously in vogue, and it's also crowded. So a lot of people are saying a lot of things. And I wanted to say things that others aren't saying or sort of exploring. And so that's kind of the motivation. And I wanted to preface the talk, which I'll aim for about 20 minutes, 15 to 20, by saying I think we can sort of judge, people if they're AI skeptics or AI sort of positive. And I think that's, like I would be sometimes guilty of that, right? Like, oh, people love AI, But I think having an open mind towards each is really important. And that's kind of the position I want to sort of end up with, right? Like, it's not so much, should we be skeptical? Should we be in favor of it? It's more like, what information do we need to, and how do we scaffold our thinking to make sure that it is as informed as possible, that it's grounded, coherent, it makes sense, all of those broader questions, which is kind of what I wanted to achieve with my research. And that's kind of just what I wanted to preface it by. So I didn't know who was coming, so I just put that there. I love the Wallabies. I understand we're in Melbourne, so nobody, absolutely nobody cares about the Wallabies, but I love rugby. Not because I'm in New Zealand, by the way. I fell in love with rugby because I watched, in 2019, I was in Melbourne and I was at my friend's house and I watched the Wallabies absolutely pants the All Blacks in Perth, 47-26. And from that moment, I was absolutely hooked. I love rugby. I love football as well, but I love rugby greatly. So that's kind of just about me. So I guess I wanted to just outline that today I'll talk about kind of situating the issue and then outline the paper that's been accepted in the Monash Uni Law Review coming out next June, I believe, or July. And then frame that as part one of what I will present next, part two, this theory of cognitive relationality, which is probably a more daring theory of legal systems to kind of give a normative ballast or grounding to some of this discussion, and then where to next? Because I think a lot of these discussions, they cannot be final. They need to be opening the door for a conversation. So that's kind of where I'm aiming to go. So the issue, I think, is best summarized by looking, well, not summarized, I guess. There are many vignettes, right? On the one hand, you've got the potential, right? So many lawyers would advocate using AI tools like LexisNexis Protege, Thomson Reuters Co-Counsel, Harvey, etc., and they would um, extol the virtues of these products. They would say, "Man, this is saving me so much time. I don't have to pay as many juniors, etc." Right? And they would say, "Wow, this can help me do so much research and so much drafting. I can build agents to help all my workflows." And a lot of that discourse is happening. And so a lot of lawyers are saying that, and some of the academic research is actually demonstrating market increases in efficiency in legal tasks, in law exams. And one paper today I saw was about how generative AI tools can mark law exams as well as legal educators can. Which, I was like, okay, I mean, that means I don't have to mark. Is that? So, so that's kind of that's kind of the discourse, right? Like a lot of that sort of positive discourse about what it can do in the law. And it's not just for lawyers. There's discourse about kind of how it can help uh, long-standing access to justice issues, online dispute resolution, small value disputes, all of those kinds of things where there can be backlogs and inefficiencies. AI is saying, look, people are saying, well, AI technologies can actually help, resolve or address some of those issues. So that's that. There's also from a law reform perspective and sort of a legislative perspective, use of AI to, for example, automate submission review, especially when you have public consultations and you've got a lot of submissions. That's kind of in the discourse, right? So that's kind of potential of generative AI technologies. And I won't go through kind of a what is Gen AI, like you can read the paper if you want. But I think we're also sort of broadly aware of the tools that are popular and being used. There's also I guess, the bad, which is, at the moment today, I've looked at Damien Charlaton's hallucination database, and that's 666 legal hallucination cases and counting. That's not all lawyers. A fair few of them will be litigants, like pro se litigants. But that's just an indicator, right? And increasingly, you will see sanctions becoming more and more severe. In a 2025 Canadian case, Cohen Lee, the lawyer was referred for criminal contempt of court proceedings. In a Michigan judgment, sorry, not a Michigan judgment, in one of the US judgments, a lawyer had the cost of the AI use was $86,000, right? So that was the penalty that was imposed. So that is significant, right? Like that's, pretty, it's not a big, not just you can sweep it under the rug.
There was cost thrown away, was it, in that case for
I think so, like wasted cost, or it may have been the penalty. I'm not sure, but one of them is in that BYO Planet case. Either way, right? Significant, orders, compensation orders against the lawyer. So there's that, right? And on top of all the market concerns about AI in the law and more generally, we've got hallucination risks. We've got the risks of getting things wrong in both research and advice, and so you've got two parallel conversations that are happening, right? I think that's kind of where, and they're diverging, right? They're diverging in keeping with our polarized times. So the legal tech people are saying this is amazing, and skeptics are going the other way, saying this is awful, right? And so I think the value is actually to come together and to say, well, what's a good way to think about the debates? And that's kind of what I wanted to achieve, right? So I do reach conclusions, but I think even if people disagree with the conclusions, they can at least have a framework to think through these things. So I started the first paper as a rage write. I was like, "Oh man, this sucks," and it was quite funny because I rage wrote it, and I sent it to a colleague and she's like, this is good, but you need to like engage with the literature. You can't just say what you think. I said, that's fair enough. And so I did that. I pretty much cited everything and engaged everything there is that I could find about Gen AI and the law in this paper, and that I think made it more nuanced. But it is a consequentialist critique of Gen AI used in legal practice and education, principally legal practice with implications for education. Okay, it's saying that there are structural flaws that mean it actually won't be as effective as mooted to be, and therefore we should tread with extreme caution. Okay, now that's a more consequentialist take. But then I thought to myself, well, how do I provide a bit more of a theoretical backdrop to have this discussion? Like, what are the values that undergird this discussion? And so that's where I came up with cognitive relationality, which is a more deontological, values-driven take on the nature of the legal system and the administration of law. And people may disagree, but I've realized as I develop as an academic, I can say what I like, and then people can disagree, and that is the academic task.
Good on you.
You know, it's basically, is it coherent, rigorous, and grounded? That's the task. People might disagree. That's fine. We'll have the discourse. So that's kind of what I wanted to achieve. So the paper I won't go through in great detail, but the skeleton is basically the discourse is a lot about risk and opportunity, right? That's the paradigm of a lot of the discourse on Gen AI and the law. The idea that, look, we can mitigate risks to take advantage of significant opportunities and efficiencies, right? That is people aren't unaware of the risks, but they say the risks can be ameliorated and managed and controlled. I challenged that paradigm in the paper because I said that, well, generative AI technologies, no matter what they are, no matter who makes them, no matter if they're legal tech or generalist, they have two structural flaws. Number one, there's the reality flaw. They're not tethered to reality. Therefore, anything you ask it to output, right, it may be right, but it may also be wrong, and there would be no way of ensuring that the machine is structurally going to reflect reality. And I was thinking on the way over here, what's a good analogy? Why do you use Microsoft Excel? Right? If you think about Microsoft Excel, why do you use it for formulas? You use it because you know it'll be right 100% of the time because it reflects mathematical reality. Why do you use a calculator? Not because it saves you time, even though it does. You use it because it's going to be 100% correct. 2 plus 2 will always equal 4, no matter how many times and how complex the equation is. There's 100% accuracy.
Can I just put something in here like along those lines, maybe? Except it's not 2 plus 2.
Yeah.
It's the human capacity when we're working in an office and we say, you know something, I think that issue was handled back in 1932, and I think that this is the name of the case or whatever. But the human in us will say, but there is some doubt here.
Mm.
And then I think maybe one of the things that you're suggesting is when an AI tool comes back with some information for you, none of that doubt element is expressed by the AI tool.
100%. And the reason for that is it has no comprehension of reality, right? It is a trained model on input data. Now, that input data may be very high quality, but the thing is that it's fundamentally about statistical correlations, right? That's the input data. And so that's why you cannot trust its output. And I'm not saying that. The AI tools themselves have disclaimers on them all the time in small font. AI can make mistakes. You shouldn't trust. That's literally what they say. If you look at Copilot, ChatGPT, etc., even LexisNexis and other tools will say that, right? So that's the reality flaw. The transparency flaw flows from that, in that if we cannot trust the connection to reality of the output, well, we need to see how the decision-making process happened, right? Just like if you couldn't trust the calculator made 2 plus 2 is 4, you need to see that it got to 2 plus 2 equals 4. Then you can be, okay, well, it's true. Problem is there's technically no clear way to do that. Explainable AI hasn't taken off yet, and there's no indication that it's anywhere close to that because these flaws are structural. There's a black box reality to many AI tools, right? And I'm not saying people can't build tools to overcome these flaws. I'm saying they're there and they're fundamental. right? Because of that, I said there's a new paradigm needed, and I put this forward here. The paradigm is, well, it's that equation firstly. The net value of an AI tool is its efficiency gain minus its verification cost. And that's simply because the efficiency gain is there. It could save you hours of time doing research, drafting, whatever, right? That's beyond doubt. But the verification cost the verification cost is necessary to get an actual value out of it. Now, there's two elements to this. Number one is the framework. So even if you don't agree with and you think that actually, no, it does save time and whatever, and that's fine. But what I've given is the framework to have that discussion. And so I've put there 4 quadrants, based on efficiency gain and verification cost. My theory, based on kind of the anecdotal discourse, is that when you get to the uses for which AI is mooted in legal practice, the efficiency gains, as they increase, will be met by a correspondingly greater imperative to verify. Think about if you have a set of financial documents or company documents that need to be reviewed for due diligence, right? If it's 100 pages, right, the efficiency gain might be, I don't know, let's say you might save 2 hours, right? Let's just say that. If it's 1,000 pages, as it could be, well, you might save 10, 15 hours, right? But given what we know about the structural flaws, the time you would need to verify that to the degree that is necessary for legal practice is going to correspondingly increase at a greater degree. That's the theory. I have had people say, well, it's just theory. I'm like, that's the point. It's a theory. You can test it if you want. That is perfectly fine. But the positing of the theory is itself a novel contribution to the scholarship, right? It advances the thinking. That's the goal, right? So that's my theory. And just anecdotally, it's funny because on LinkedIn just blew up, right? Blew up. A lot of people are like, this is totally my experience, right? Like as a lawyer, totally my experience. Then legal tech people are like, no, actually, it's that. But my sense is that I don't see a lot of people telling me that actually, no, it has saved a lot of time, right? Like I have more people saying to me that this is true. And anecdotally, I've had people like lawyers from the US reach out to me wanting to talk to me and say, oh, actually, it's true. And we want to get you on a podcast. We want to talk to you kind of thing. Head of a major litigation firm in Washington reach out to me and say, hey, can I talk to you? And I was like, oh gosh, it's more just this idea is resonating, which is pretty cool. So what I've done there is I've kind of just documented, okay, well, in the bottom left quadrant, what you've got is kind of like your internal memos, business development, stuff that like is kind of nice to have, but it's not the core of the legal practice task, right? The top right is the one where, look, you do have various studies that show some efficiency increase, but what I argue is they don't account for the verification imperative. And as Chief Justice Bell of the New South Wales Supreme Court says, much more than efficiency gains are in play. So that's this theory. And I basically talk about why is the verification imperative so high, right? If we say that the verification imperative will outweigh the benefits, why is that so? Well, I say it's because of 2 things. Number one, the cost, because the legal task is not just binary. It's not just the case of, does this case exist? It's does this case stand for the proposition for which it is argued to stand, and all the other things that we do as lawyers that rely on integration of the law and advising clients on situations, right? And that's what JNE 24 says, the court in JNE 24. So a lot of that is in the paper. I also say that the imperative to verify to that degree arises from both the rules governing practitioner conduct and judicial statements. The judges generally are quite hard on AI use. They're really nutting down on, okay, don't bring this before us. Like we really don't want this. So I conclude in the paper by saying, look, lawyers and law schools should be reticent about integrating AI into legal practice and education until these flaws are comprehensively addressed. And I just wanted to flag there, this doesn't mean you walk in without being aware. Teach people and train yourself in awareness, but that doesn't mean integration. And I think a lot of people say awareness equals integration, and I just disagree. You can be aware of something, but not integrate it. Okay, so that's the first part of this two-part approach to the question, and so it's more consequentialist. The second part is, well, it's a response to this question by Chief Justice Nile, who I just learned today is a Monash alum and gave the address at the Monash Uni Law Review dinner, right? So he gave an address earlier this year, and he was talking about, well, we got to think about to interrogate what tasks and functions it is appropriate to delegate to AI and to what extent we should do so. So I said, okay, let's write a response to that based on that word appropriate. What does that mean, right? So not just consequentialist, what is effective? That'll change. But more value-driven, deeper, right? And so here's the theory. It's a theory of cognitive relationality. That is, the flow of law in common law legal system is acts of cognition administered relationally. Now, being fully transparent, given my packed schedule, I did not complete my slides. So I will speak to the paper when I finish my slides. But I think I've got the important things here. So I've set out this paper that's under review, the jurisprudential foundations of the theory, and really perhaps the constituent elements would be another way to describe it. When I say law, I mean the collection of legal rules governing a society emerging from authoritative legal sources, namely Parliament and the courts. There is obviously an entire body of scholarship on what is law, and I was told don't open that door too much, essentially, was the kind of. So I was like, I'm going to mention Raz and then run away. So, but I have grounded that, I think, in the jurisprudence, and I'm confident of that. And I would, it was funny, I was going to present this to some legal theory colleagues at Auckland as part of a faculty seminar. And in my project management spreadsheet, which I have all my tasks there, I said, prepare for pain. Because I was like, the jurisprudence are coming for me. They haven't yet, so that's good, I suppose. But so that's law, legal system. I define as the structure against which the law flows. I've cited Nicole Rowan, my colleague, who says, when we say legal system, do we seek to explain a system of legal rules or legal institutions other than rules, legal principles, agents, practices, or perhaps all of the above? To which I would say two things. Number one, it means that definition is malleable. And number two, I would probably situate it in that legal institutions kind of definition, but obviously open to debate. And then I have this phrase that called the administration of the law, which I talk about as the flow of the law from and through institutions and actors. And that kind of looks like this, right? Lawmaking majority in legislature makes legislation is enforced. It's interpreted, the law is applied, so both the interpretation of the law by the courts and the development of common law. The public responds to how the law is, either by consultations, elections, and direct democracy, and that leads to a lawmaking majority in legislature and so on and so forth, right? And obviously courts, Parliament, and the executive appoints judges. I have cited in this paper why I've grouped the executive and the Parliament, and that reflects the theory of responsible government. So I have justified that. I was thinking about that for a while. This is funny because I'm not a constitutional or public lawyer at all. Never thought I would. Okay, so this is where I finished I got to with my slides. But basically, I then wanted to talk about the constituent elements, right, of cognition and relationality. And basically, what I started with was the idea of relationality. And that's the idea that the four actors in the theory, Parliament, the courts, the public, and lawyers, are bound together in relationships with each other. This draws from relational jurisprudence, which is a term used by Maximilian Del Mar and Ian McCormick's institutional legal theory. Okay, it views the legal system as one defined by relationships between these actors, and relationships are defined not just by legal obligations, but by something more than legal obligations of good faith, trust, goodwill, sort of more intangible obligations, right? So that's kind of the first part of the paper, and I sort of go through, well, why does this relational structure exist in that way? And I go through each of the relationships there. For example, the administration of the the legal rules from the parliament to the public. There's a relationship there. The relationship between the courts and the parliament, one of interpretation, but also a relationship of trust between them. And then I say, well, the flow of law is the administration of cognitive acts within these relational structures. Okay? Cognition defined here as the suite of human abilities that enable or comprise human thinking, not Kelson's conception of legal cognition, right? So people would say, well, Kelson said, I'm like, yeah, I'm not talking about that, right? So that's not what I'm not talking about Kelson. And so I basically say, well, the lawmaking task is a human act of cognition, right? It's making laws that reflect the interests of, at least theoretically, the interests of the public, that help society operate, well and effectively. The law interpreting and common law developing tasks is a task of cognition. The judges apply their judgment to disputes and develop the law in that way. The legal profession is that as well, right? The lawyer-client relationship is fundamentally one of trust and the application of cognitive intuition and skill. And the people themselves, right? They engage with these institutions and actors in ways that have relationships. We trust the parliament to administer laws in our favor. We trust the courts to administer disputes in an unbiased manner. We trust lawyers to advise us on the nature and scope of the law and the application of the law.
Be careful about trusting lawyers.
Well, that's the thing. I was going to say, right? That's very much a theoretical point. So that's kind of the theoretical basis. And then I said, well, that's descriptive. And I said, well, that's actually like desirable, right? It's the concept from McCormick's idea of a normative order. Normative order is a kind of ideal order. It's practical. It is an order that is envisaged as a practically realizable state of the world, given things as they are and personas as they are here and now. And I say, well, why does this theory work? Number one, it ensures participation by the public in the administration of law. Number two, it ensures protection of the public from abuses of power through advocacy. Three, guardrails against the development of laws that unduly oppress the public via judicial interpretation. Four, requirements for public institutions to exercise their duties as to the law in line with higher ethical standards. Obviously, like that's not going to be the case all the time. Probably more rare than most. I mean, we could have a very lengthy discussion about that. But I sort of said, look, that's what we want law to be, right? That's what we want it to, how we want it to operate. And so I say, well, that's why this is desirable. And then I talk about in the paper, well, can we then automate cognition or relationality? And I said, well, maybe you can automate some of the cognitive tasks, right? You could probably do that, but you can't automate trust. These relationships are grounded in trust between each other, or should be, which requires moral awareness. And because it requires moral awareness, at least until AI sentience, we will not have that. And because of that, I then argue, well, you can't automate that and the implications for that. Obviously, I've talked about the lawyers, but I'm just going to talk about courts. Can they automate the judicial decision-making task, as some judges have done in the US and been found out for that? My argument is, well, no, they can't. That is a human cognitive task, and the judges should avoid the potential for contamination of the legal record. In the same way, I would argue that they should not overuse their clerks to draft their judgments. I just think that's an underappreciated part of the judicial task. If we want to deal with judicial backlog and their workload, do it another way, but don't do it by, outsourcing and contaminating the legal record. Same for the submission review, which can bring into play biases and things that are in the training data, etc. So that's kind of my answer to Chief Justice Niall's question. Well, how do we determine what's appropriate? Well, does it cohere with a theory of cognitive relationality, which is both descriptive and normative? And so what I've done with the two papers is I've tried to present a consequentialist view, the structural technical view, and then more the theoretical view. And my hope is, well, people will take it and agree or disagree. And then hopefully that will inspire a more critical reflection of how we integrate artificial intelligence into the administration of law and our institutions. So that's all I had to say. I appreciate you all listening. I'm looking forward to a fascinating discussion.
Yes.
Yeah, thank you very much, Joshua. That is extremely interesting. And yeah, returning to really some foundational questions, kind of philosophical questions about what law is, and yeah, applying it to something that's really live. Um, yeah, very interesting. I have lots of questions. So does anybody online have a question?
Yeah.
Tomorrow,
Yeah.
yeah, go.
Hi Josh. Sorry, I'm
Hi,
not there
Tamara.
in person. I'll put my camera on and then you'll see why I was taking so long to react to things. It's because I'm in the car. And definitely was not driving when the seminar started because that's illegal.
Stay safe. Stay safe.
Yes, I'm parked now. Um, thank you. That was super interesting. I had 2 points. One which is a agreement, I think, an observation, and one which is maybe a challenge. So the first was I thought that your paradigm of looking at AI through the lens of those two problems was super interesting. And I think what we're witnessing with our students is that they are appreciating the efficiency gain and they are not factoring in the, what did you call it? The validation.
Yeah, verification.
Verification requirement. And I think that is most likely going to become a generational problem because we all grew up completing our legal studies without AI and learned how you do research when you don't have an AI tool. And I rely super heavily now on ChatGPT, but I hope that I'm always taking care to verify very rigorously. And I certainly don't tend to trust things that ChatGPT tells me as a matter of course, but I have the benefit of developing my skills before that came along. So I really think the onus is on us as teachers to drill into our students so hard that without the verification, there is no efficiency gain from ChatGPT. And with the verification, there's not much efficiency gain from generative AI. But the consequences, if you don't take that time to go through the verification exercise, could be catastrophic. Like, you know, as you mentioned, like lawyers using unverified claims in court and such. And then my disagreement, I don't know, we'll see what you think of whether it's a disagreement or not. So you mentioned right at the end then this idea that we don't trust AI and we can't trust AI because it isn't human. But I think anecdotally from what I've seen and the way that I use ChatGPT outside of a work context, I think people do trust it. I think that there are a lot of people out there who are developing, like, for want of a better word, like parasocial relationships with ChatGPT or with other AIs. And I think there's
Sorry, Tamara, you've cut out the sound.
oh, can you hear me now?
Go again. We can't hear you.
Am I back? Hmm.
There we
You're
go.
back. You're back.
Yeah.
I'm back. Okay, yay. Yeah, I think that there are a lot of people who have developed these like parasocial relationships with AIs, like to the point where they do trust them deeply.
Yeah.
And I mean, for example, again, shaming myself, I pulled a muscle at yoga this morning. Did I go to the doctor? No, I hate going to the doctor. I went on ChatGPT and described my symptoms in excessive detail and then asked it for a treatment plan. Um, and that's just a minor example, but I think, yeah, look, ideally we don't trust the generative AIs, but I don't think that reflects reality. I think there are a lot of people out there who are trusting them with very important things when they absolutely shouldn't. Worse than they meant.
Thanks, Tamara. That's I appreciate that, and I think I don't think it's a disagreement, and I just think it observes the reality of where people are at when we're seeing the implications of that trust, right? With chatbot suicide amongst teenagers and the social media ban has just come into effect, right? That's the response to how seriously the governments are taking. Perhaps they're talking about social media, but chatbot suicide and things are undoubtedly a concern. So the reality is, I think there's the deeper question is about epistemology, right? About how do we determine what is true and how do our processes of ascertaining truth, you and I and Duncan and everyone else pretty much in this room, yeah, grew up where we could verify content ourselves, right? But now you're right. This is probably the culmination of the post-truth era, if you like, right? The only reason AI takes off like this is because it's been primed in a world where truth no longer matters, right? Where facts ultimately are at the behest of the powerful. And so I think that's an interesting point, and one which I think I can work into the idea that, look, what kind of trust do we want, right? In the administration of law, and what does that mean? So I absolutely appreciate that.
Thanks, Josh. And then we just had Lisa next as well, and then we'll come to Mel. I just want go ahead.
Just on the trust point, it just the way you asked the question tomorrow made me think that on the one hand, we're talking about subjective trust, and we quite clearly a lot of users, including myself, subjectively, I form a view about whether a piece of information is trustworthy or not. And I just wonder whether, Josh, was in your paper, whether you're thinking about a more objective trustworthiness. So that's what cannot be automated.
Yeah, and I think I'd probably bring that out a bit more clearly, just because obviously I realize with delving into this theoretical stuff, you're like, the minute you say a word, the people will sort of jump on it, and I think that I'll bring that out more clearly. But I do appreciate the point, Tamara. It's it can be on a spectrum. I think that's the thing, right? Trust can be on a spectrum. You wouldn't trust ChatGPT with your intimate financial details, but for stuff that you probably, you know what I mean? Like, it's kind of just.
Although, as the relationship develops, people might start.
Maybe they will.
And do.
And so I know there's another question waiting, but just to sort of continue that point, I wonder if this actually, this capacity to have trust in sort of AI is itself an example of a situation that is not based in the reality of the human condition. Maybe actually that sort of cognitive sort of relationality between humans actually has always an inbuilt element of a degree of mistrust that is then absent when people start to have unabounded confidence in AI. So that is in and of itself an example of something that is not based in reality.
Well, it's the risk of any relationship, right? That's paradoxically what makes it valuable. I mean, you take romantic relationships as an example. You invest in those relationships particularly deeply. The risk is that you could be hurt, right? And the same with sort of deep friendships, I suppose, of any sort. But that trust develops because of that. That risk is not eventuated time and time again. Trust is built and built and built and built and built. But with AI, I think the example I used earlier of Microsoft Excel, there's no risk of wrong, right? In terms of the mathematical.
So you have complete and unabridged trust.
Not 99%.
No, it's 100%, which you perhaps would not ever have in your relation with another human person or human-based entity.
Correct. Yeah. No, I think that's an excellent point.
Yeah, and friendships, it's a two-way relationship where you care about each other.
Yeah.
And people think they're friends with the AI, but the AI can't care. So, by definition, it can't be a friendship. 100%. Which I think goes to the trust thing.
Yeah. Trust is two-way. Yeah.
Lisa, did you want to jump in?
Yes. Hi. Thanks. That was really interesting. And I really love that paradigm. Like, it's so simple. I feel like, it was just always there, but it's great the way you've articulated it, and I love the quadrants as well. I've just got a few sort of thoughts, and wondering if you've thought about these aspects. With the verification cost, I feel, and the discussion today has been focusing on, the context of litigation. The reality is that the bulk of what lawyers do is not in that that sort of environment, and that sort of environment is, not accessible for most disputes. But also dispute work is even a small component of what lawyers do. So I come at this from a background. I feel like everyone must think that I'm like a broken record because I always make the statement, I'm not an academic, I come from legal practice. So my experience is up until, a couple of months ago, working in-house, trying to navigate all the commercial contracts. And when you talk about the verification cost, the reality is that we don't have time to verify anything anyway. Most lawyers don't have time. Most contracts, unless you're looking at really big transactions, are completely flawed. There's limited time to check all the details, and most contracts are not even being processed by lawyers. So I just see huge potential for it to augment that process that's already very flawed. So that's one thing. It's I guess thinking about the different types of works, and I'm particularly interested in its role in drafting contracts. And actually, those are the 2 points because they relate. So it's looking at not just the litigation, which is a small part of the law. It's much bigger of legal work, and then that impacts on how you assess the current situation of what we're dealing with and the verification cost.
Yeah, no, thank you, Lisa. I appreciate that. And it is one of the things when I was writing the verification paper was I had to get away from a litigation-centric view on this, right? Because that's not the breadth of legal practice. And so probably a couple of things. One, I did sort of I think I would still extend the claim insofar as it's involved in drafting, research, and the transactional side of law. But because law there's transactional practice and like commercial practice, and then there's the disputes practice, right? And I would say that, well, if you're producing content of any sort, because fundamentally the task of the litigator is actually not that different from the task of the transactional lawyer. They are both using AI to produce content, whether that's submissions or affidavits or contracts or reviews of documents. It is content production. So if any content is produced, then I would say I'm not saying the theory holds. I'm saying that the framework is reflective. So that's probably what I would say. In the paper, there was one statement from a judge where I think it was Dame Sharp in Allende, but she basically said she reminded the lawyers that this is not just an obligation for verification in litigation context. It applies to all of legal practice. And she specifically mentioned all of legal practice. And I took that and I said, well, okay, here's a judge of the King's Bench of the High Court of England and Wales saying you need to apply the same standards of rigor to the quality control you would give to advising a client, independent of litigation, or drafting a contract for them, or drafting a will, or drafting a shareholder agreement, or anything like that, doing DD work, as you would presenting submissions or affidavits or other evidence or documentary work to the court. The same standard applies. The second thing I would say is that the reason litigation is in focus is because it's publicly available, right? The judgments are there. We can see the judges criticizing lawyers in real life for these mistakes. We necessarily have not seen that in transactional contexts because they're probably less visible, right? We would see professional discipline, and that's not always visible, right? And professional discipline by regulators is the visibility of that is variable. Secondly, I would say the role of professional indemnity insurers is underplayed in the discourse. Insurers make the world go round. Why is there drama on the east coast of Australia? because insurers are saying we won't insure the houses. And people are saying, well, I can't sell my house and I can't buy a house there. That's not a legal problem. That's not a rights or constitutional problem. Everybody has the right to purchase a house there, and people can purchase. But the reality is the bank won't lend unless you have insurance. So insurance does make the world go around, and you can't practice law if you don't have PI insurance, right? If you're a sole practitioner or a law firm, you are bound by the risk your insurer is willing to have to bear in exchange for your insurance premiums. So what I think needs to be investigated further is, what do insurance companies think about the use of AI in legal services? It would be a very interesting exercise if a PI insurer said, you know what? If you are going to use AI, you need to have all these disclaimers. You need to get your client's signature on it. We need to verify. It would be insane. But we do have precedent for that. Like sometimes insurers will be like, we want to be involved in this, right? And so I think the reality of this is that, yes, it is litigation centric, the discourse, but that's because that's the data we have. I would be interested, and I think this is a point of testing the theory. I think it'd be interested if empirical work were conducted to interview lawyers and managing partners and insurance, PI insurance providers, as to kind of what are your views on that, and also what are your clients wanting, right? Do they want you to use AI? Because anecdotally, I spoke to one of those lawyers that contacted me, the head of a big litigation practice in Washington. He's like, hey, I want to talk to you. I said, okay. And so I took the opportunity to ask him. I said, hey, are your clients kind of wanting you to use AI? He's like, well, some of them do, and some of them don't. Right? I was like, oh, okay. Like, that's interesting to me, because I'm like, it's not then uniform, and it's also not up to the lawyer, right? The lawyer has to run that by the client probably in the terms of service or terms of engagement. Say, hey, we're going to use this particular AI tool that's protecting your data and etc. In this delivery of the service. So all of those factors, to me, are factors that A, suggest the need for caution, B, suggest the need for further research in that transactional, commercial, 90% of legal practice context that you were rightly mentioning, right? No, not everyone's a barrister.
Yeah. Can I make another comment on that? I mean, I see like there could be a real market shift here, because so my experience has been like working in-house, and I mean every lawyer works with in-house lawyers anyway, because they give the instructions to private solicitors in private practice. But I mean, I'd be interesting to know, but I would think maybe there's going to be a shift for recruiting in-house, because a business can then make the decision, well, the insurance, that self-insurance, it's basically you'd have the qualified lawyers, and you would take a risk on AI where it's effective, but there are going to be mistakes, and there are always mistakes. Mistakes happen all the time, but there's going to be productivity gains, but in a way that a lawyer actually charging for their services may not be able to compete with.
Yeah, I think that would be that's going to be
because
super
of the
interesting.
verification cost requirement. Did that make any sense?
Yeah, you slightly dropped out a little bit, Lisa, but I got the gist of what you're saying. I think risk appetite is the other element, right? As you were saying, is if the company or the client is willing to take the risk that there will be mistakes and bear that cost, well, I mean, that's half of the cost. Go for your life, right? Like, I think the problem is when we have situations where, oh, how could this mistake happen? How could this citation, hallucination, whatever you want to call it, happen? And that's where the reality is. Now, I wanted to say that the story that I tell in these presentations that hits it home for me, right? Or that really integrates it, is one that was recently in the news, right? In Melbourne. Rishi Nathwani KC, he's a barrister in Melbourne. He's he was defending a boy accused of murder. 16-year-old boy murdered a 41-year-old woman, or alleged to have murdered. Now the boy gets off eventually, not guilty by reason of mental disease or defect, I think. I use that term from Law and Order SVU. I don't actually know what the criminal law equivalent.
Maybe impairment.
Well, yeah, maybe impairment.
Yeah.
So I guess all's well that ends well, but he and his junior get reprimanded by the court for AI generated hallucinations. Made the news, everything, right? And it's on Osli. Now, the only negative in that case was, it was a 24-hour delay in the proceedings. Like that was the only delay. And so he apologized profusely to the court for that. There was no professional sanction as far as I'm aware. Obviously, the court's like, "Yeah, this is not good," but that's about it. I approached that thinking to myself, put yourself for the moment in the position of the family of the accused or the family of the deceased woman. This is the most traumatic, horrific event in your life that nobody wanted to happen or expected to happen on both sides, right? And if we're talking about mental impairment, there's obviously even more trauma or tragedy to that. How would you feel in that depth of trauma to know that this lawyer you have paid through the nose for as a KC? So this is no joker as a lawyer. He's been recognized among his peers as being the cream of the crop, has phoned in the act of defense by using AI to hallucinate. Can you imagine the rage and anger, the humiliation and embarrassment you would feel, right, as the lawyer, but also as the clients, right? To me, that hits home powerfully that, okay, right, we need to take this much more seriously for the good of the clients that we're serving. And I include in-house clients as well, for businesses as well, because they are our clients. Our obligations to the court and the administration of justice don't stop because we're in-house counsel. That's our client. And so for me, that's the story that really hits home. I'm like, that was a KC. He should know better. And I think that's professional misconduct, not because I'm high and mighty. I'm like, because think of the clients. They deserve better than that, right? And so for me, that's why I'm like, no, this is not okay. And we really need to take a harder line if we are to restore that trust that you say people don't trust lawyers. Well, this isn't helping, right? So that's kind of where I'm at. But I think there's a need for nuance, Lisa, in my thinking from what you've said about the practical realities of engaging it in legal practice in ways that do, enhance productivity in ways, right? And then telling our students that maybe there are some uses. I appreciate the thoughts.
So Lisa's maybe saying mistakes happen either
sorry,
way.
just one final.
And maybe, yeah. And anyway, no one reads the document.
Yeah.
She's suggesting. But Josh, you're maybe saying the mistakes are of a different kind than the mistakes made by human beings.
Well, I'm just saying that
they're not really comparable.
Yeah, maybe that's the mistakes are fine, right? Maybe that's fine. But I think if that's the case, the client needs to be aware, right, of the risk, accept that risk, right? The insurers need to be okay with that. And we just need to be protected then as lawyers that we told you what we're going to use. We told you of the risks. You accepted it. And therefore, this is on you. Like that's probably it, right?
We'll come back to Lisa in a second, but yeah, anybody else in the room?
Well, no, to continue that point, I think it is arguably of a different character because it's not merely a dereliction of duty, it's almost a delegation of duty when you outsource it to AI, and as a result, there's an error in the work product. But I think the Victorian regulator, is largely in accordance with you as to the severity of this, because just in October, a matter was referred by, I think, the federal court to the regulator, and they took away his unrestricted practicing certificate and said, you're unsafe.
Yeah.
And so you now need to go back to restricted practicing for 2 years. And that was considered by the profession, as I understand it, to be a very sort of onerous and almost disproportionate sort of order that was made on him. But that reflects the severity of how this is being considered.
Yeah. There's a Dial case, I think. Yeah, that guy. Yeah.
That seems so reasonable to me that if someone uses a false reference, that's professional misconduct, like whether you have your certificate restricted or whether you are struck off, like depends on the gravity. But like, it's not okay to lie to the court, and that is lying to the court, and it's not upholding your fundamental duty to be aware of the law. And I mean, like, I would have so much more sympathy if it was a legal aid lawyer with, 20 cases on per day versus whether it was a KC who's getting paid $2,000 an hour or whatever. But yeah, where is the line if it's not that?
Yeah, 100%.
Mel, did you want to add anything before we go back to Lisa for final comment?
Just the kind of something echoes in my mind, and I think you said it toward the beginning of the seminar, and that is that, but it might have been you, sorry, that AI doesn't care if it is wrong.
Doesn't care.
So that's a pretty critical starting point. Now, why do we care? It's because somewhere around at some stage in our lives, we start to learn about the law, and we do care about what we're learning about, and we do take on personal responsibility. And then there are a series of steps that are designed to allow us to reach the level where we can deliver services with due care and skill. So when that's the starting point, it makes me feel a little bit more secure in what humans are doing. So anyway,
Yeah, no, thank you.
Interesting how we come back to the human element, isn't it? Of the state of being a human person and the human condition and what that means relative to AI. You often do end up coming back to a consideration of what it means to be human.
Yeah, absolutely.
Lisa, sorry, you had one more point that you wanted to make.
Yeah, look, the other thing was so just thinking about how this might be. I mean, I think it's inevitable it's going to somehow be implemented in legal practice, but I mean, often lawyers will, include. It's very typical, as you all know, to include a disclaimer in your advice, as in, I was not able to, and that happens in the quotation. It's like, I'm going to charge this much because I'm going to do X, Y, and Z. And if something else happens, I'm not going to look at it. And so even reviewing a contract, often there'll be a carve out for we won't have time to review all the linked terms and conditions. We're just going to look at this part of it. So, I just see maybe there's a way that, I guess also just to say that happens as well, that there are ways of crafting the market working out what is the scope of what's being looked at. Yeah. And
Thanks, Lisa. And just finally, Tamara or George, did you want to add anything?
No, but I mean, this has been fascinating. Thank you so much, Josh. It's really interesting to frame all of these things that we think about and grapple with on an everyday basis in a more structured way. So thank you.
Thanks, Tamara.
Yeah, no comments, but just a privilege to be here. As an undergrad LLB student from the University of Auckland. Thanks, Josh.
Oh, hey, George. Sorry.
No worries, Josh.
Share the link.
Joshua was my contract law lecturer. Yeah.
I recognize you. I was like, oh gosh. See, I am doing a good job. I think. I am not wasting my time. Thanks for coming.
That's all we've got time for. Yeah, really, really fascinating couple of papers. And I think, it was drawn out in the discussion that, you've covered both sides of it, both the consequentialist side, where it's, we're making mistakes, does it matter? And then also the other side, is AI completely different to the human being? And does that matter as well? Really enjoyed listening to your presentation of that. And I look forward to seeing where this goes.